All of us have individual rights and freedoms that belong to us simply because we are who we are, human beings, men and women. There are principles and laws that are in operation which are there for the benefit and protection of the individual. This is called the rule of law. Right now, most of us are being governed and controlled by laws which have been created by the government and impact our life. Law, the regime that orders human activities and relations through systematic application of the force of politically organized society or through social pressure, backed by force in such a society. The legal system, respect and obey the law. Within law we find natural law, a physical law of nature, a philosophical system of legal and moral principles purportedly deriving from a universalized conception of human nature or divine justice rather than from legislative or judicial action. Natural right, a right that is conceived as part of natural law and that is therefore thought to exist independently of rights created by government or society, such as the right to life, liberty, and property. See natural law. There are natural human rights and freedoms that are in operation for all of us to exercise and stand under. These rights and freedoms are not created by the government, but they are recognized by the government. Many of us are not aware of the fact that there are rights and freedoms that exist for use to stand under, which give us our full legal capacity before the government. These rights are not given or created for us by the government bodies. They existed long before the government did. Thomson Newspapers Limited v. Canada, Director of Investigation and Research, Restrictive Trade Practices Commission. While individuals as a rule have full legal capacity by the operation of law alone, artificial persons are creatures of the state and enjoy civil rights and powers only upon the approval of statutory authorities. The individual may stand upon his constitutional rights. He owes no duty to the state, since he receives nothing therefrom, beyond the protection of his life and property. His rights are such as existed by the law of the land long antecedent to the organization of the state and can only be taken from him by due process of law and in accordance with the Constitution. He owes nothing to the public so long as he does not trespass upon their rights. These rights that you have and can stand upon are described as follows. Inalienable right, a right that cannot be transferred or surrendered, a natural right such as the right to own property. Absolute right. 1. A right that belongs to every human being, such as the right of personal liberty, a natural right. Thomson Newspapers Limited v. Canada, Director of Investigation and Research, Restrictive Trade Practices Commission. While individuals as a rule have full legal capacity by the operation of law alone, artificial persons are creatures of the state and enjoy civil rights and powers only upon the approval of statutory authorities. Artificial person, an entity, such as a corporation, created by law and given certain legal rights and duties of a human being, a being, real or imaginary, who for the purpose of legal reasoning is treated more or less as a human being. The regulations and enactments, statutory power, that the government creates to restrict your actions are not the supreme law in Canada. They are indeed law, but they are not the supreme law, and if these enactments limit or remove your natural rights, the enactments have no force or effect against you. You do not have to yield and obey the enactments. The Canadian Constitution Act of 1982, as declared in Section 52. The Constitution of Canada is the supreme law of Canada, and any law that is inconsistent with the provisions of the Constitution is, to the extent of the inconsistency, of no force or effect. The government and all the ones who operate in the government office are controlled by the Constitution Act. They are obligated to respect our individual fundamental rights and freedoms. They cannot take actions against us that limit/abridge our fundamental rights and freedoms. Slate Communications Incorporated v. Davidson, 1989, 1 SCR 1038, 1989. The reference in S. 32 to the Parliament and a legislature make clear that the Charter operates as a limitation on the powers of those legislative bodies. Any statute enacted by either Parliament or a legislature which is inconsistent with the Charter will be outside the power of ultra vires, the enacting body, and will be invalid. It follows that any body exercising statutory authority, for example, the governor and council or lieutenant governor and council, ministers, officials, municipalities, school boards, universities, administrative tribunals, and police officers, is also bound by the Charter. Action taken under statutory authority is valid only if it is within the scope of that authority. Since neither Parliament nor a legislature can itself pass a law in breach of the Charter, neither body can authorize action which would be in breach of the Charter. Thus, the limitations on statutory authority which are imposed by the Charter will flow down the chain of statutory authority and apply to regulations, bylaws, orders, decisions, and all other action, whether legislative, administrative, or judicial, which depends for its validity on statutory authority. Here the courts are giving us a clearer understanding of who we can hold accountable if they try to breach our fundamental rights and freedoms. This list is not exhaustive. The governor and council, lieutenant governor and council, ministers, officials, municipalities, school boards, universities, administrative tribunals, police officers are also bound by the Charter. Municipalities and their councils are bound by the Charter. Administrative tribunals are bound by the Charter. Any power that uses an administration process upon you, whether it is internal or external to this body, these people are subject to the Charter, and they're not allowed to make a judgment against you or take actions against you that violate your Charter rights and freedoms. Thus, the limitations on statutory authority which are imposed by the Charter will flow down the chain of statutory authority and apply to regulations, bylaws, orders, decisions, and all other action. So what exactly is this Constitution, and why is this important to me as an individual? The Constitution Act of 1982 changed the power structure here in Canada. It is what has given you the ability to stand and force the government to respect your natural, fundamental rights and freedoms. Prior to the Constitution of 1982 law was set up, law operated on the grounds that you and I, as individuals, were expected to surrender our fundamental rights and freedoms for the greater good of the public. Public order was the supreme law of the land, and our natural rights could be limited and abridged, and there was nothing we could really do about it. The government would create laws, taxation, property tax, license, and permit fees, and we were forced as individuals to submit to these laws. Since the advent of the Charter, this has changed. Now public order is submissive to our individual natural/human rights and freedoms, and if the enactments, public law, the government creates, tries to limit or remove our natural rights, it's of no force against us, and we can hold them accountable for breaking their obligations. R. V. Hines, 1999, Chi 18979, and LCA 83. Prior to the Charter's advent, the individual really had no special means of protecting against incursions upon his or her basic fundamental rights by executive or legislative arm of the state. There were no means at the disposal of individuals to muster court challenges aimed at invalidating legislative, executive, or administrative acts. 84. Respect for the rule of law, upon which, as W. Ivor Jennings in his text entitled The Law and the Constitution, University of London Press, 4th edition, points out at page 42, hinges the existence of public order, mandated compliance with directives and ordinances even if they infringed upon individual fundamental rights and freedoms. 84. A primary purpose of the Charter was to change this relationship of the individual with the state and its laws by endowing individuals with an effective means of challenging acts of the state in courts on the ground of violation of their constitutionally protected rights and freedoms. The Charter is not something that the Canadian government just decided to create on their own. As you can see, this Constitution Act of 1982 has caused the government body to lose its ability to force individuals like you and I to obey the enactments. Why would the government do such a thing in 1982? In 1967, the nations of the earth came together and created the Universal Declaration on Human Rights and Freedoms. This declaration was an expression of natural law, natural rights that were recognized by government bodies. This declaration did not create new rights and freedoms, but recognized them as already being available and present for man. This declaration sought to express these fundamental natural rights freedoms so that the nations of the earth would be bound to these rights. In 1976, the international covenants were given force of law. These covenants were a complete expression of the rights and freedoms contained in the Universal Declaration of Human Rights. Any country that signed upon these covenants became legally accountable to respect and ensure all the rights and freedoms that were listed in these covenants to the individuals living on or in their territory. His Majesty did indeed sign upon these covenants and is under obligation to respect these human rights and freedoms when invoked. Many individuals think that when they say the name Canada, they're talking about a territory and parcel of land. This, however, is not the case. Let us look into the Constitution of Canada in Article 91. Constitution Act 1867, Article 91. It shall be lawful for the Queen, by and with the advice and consent of the Senate and House of Commons, to make laws for the peace, order, and good government of Canada. How many of us really understand what is being declared in this simple statement? Government of Canada. What exactly is a government? Government 1. The structure of principles and rules determining how a state or organization is regulated. An organization through which a body of people exercise political authority. The machinery by which sovereign power is expressed. When we use the term government, we're simply referring to a structure of rules and principles that a body of people exercise authority. A government is a group of individuals who are exercising controlling power. Governing body. 1. Government. 2. A group of especially corporate officers or persons having ultimate control. The board of directors is the governing body of XYZ, Inc. We are seeing that a government is nothing more than a group of individuals exercising ultimate control, exercising power over how a state or organization is regulated. The following question then arises: what type of power is being exercised by the government in Canada, and why would I have to listen to or submit to this power? To find the answer to this question, we have to first find out what exactly Canada refers to or designates in these enactments. Constitution Act 1867, Article 91. It shall be lawful for the King, by and with the advice and consent of the Senate and House of Commons, to make laws for the peace, order, and good government of Canada. Juristic Federal Unit. The Supreme Court of Canada has interpreted the word Canada as follows. Supreme Court of Canada. Re. Authority of Parliament in relation to the Upper House. 1981 SCR 54. Date: December 21st, 1979. Further, although S. 91-1 gave the King the power, with the advice and consent of the Senate and the House of Commons, to alter the Constitution of Canada, except in certain expressly designated areas, it does not confer a power to amend the B&A Act. The word Canada in S. 91-1 does not refer to Canada as a geographical unit, but refers to the juristic federal unit. Juristic person. See artificial person under person. Person, juristic person. See artificial person. Artificial person. An entity, such as a corporation, created by law and given certain legal rights and duties of a human being. A being, real or imaginary, who for the purpose of legal reasoning is treated more or less as a human being. The Canada being spoken about and brought forth in the Constitution Act of 1867 is a corporate body, and we as inhabitants are being incorporated into this corporation. Since we can clearly see that Canada is a corporate body, we should be able to find subsequent evidence of this fact when Canada and its controlling powers are mentioned within the domestic laws. Constitution Act 1867, Article 9. The executive government and authority of and over Canada is hereby declared to continue and be vested in the King. Constitution Act 1867. 10. The provisions of this act referring to the Governor-General extend and apply to the Governor-General for the time being of Canada, or other the Chief Executive Officer or Administrator for the time being carrying on the Government of Canada on behalf and in the name of the Queen, by whatever title he is designated. Black's Law Edition 7. Chief Executive Officer. A corporation's highest-ranking administrator who manages the firm day by day and reports to the Board of Directors. We just saw that the Supreme Court declared that Canada is a corporate body, and when we look to the type of power in operation, we find that it is corporate powers. When we look into the enactment, which governs and controls the Governor General, we find that the executive powers that he is operating on behalf of the Queen are flowing through the fact that this corporate body is a corporation soul. Office of Governor General. Corporation soul. 2. The Governor General of Canada or other chief executive officer or administrator carrying on the Government of Canada on behalf and in the name of the sovereign, by whatever title designated, is a corporation soul. A corporation soul is a legal entity consisting of a single sole, incorporated office, occupied by a single sole, natural person. This allows corporations to pass without interval in time from one office holder to the next successor in office, giving the positions legal continuity with subsequent office holders having identical powers and possessions to their predecessors. The Governor General is the Chief Executive of Canada, and he controls what transpires in this corporation on behalf of His Majesty. He also shares this power with the Lieutenant Governors of the provinces. Constitution Act 1867, Article 14. It shall be lawful for the King, if His Majesty thinks fit, to authorize the Governor General from time to time to appoint any person or any persons jointly or severally to be his deputy or deputies within any part or parts of Canada, and in that capacity to exercise during the pleasure of the Governor General such of the powers, authorities, and functions of the Governor General as the Governor General deems it necessary or expedient to assign to him or them, subject to any limitations or directions expressed or given by the King. The Governor General and the Lieutenant Governors are operating the executive powers of the King for the Corporation of Canada. The ministers are appointed into their position, and they operate the executive powers on behalf of the King. We are seeing that the governors are the ones who are operating the executive powers for this corporation designated Canada. In the Crown's statutory instruments, it is being declared that I and my fellow men and women are being incorporated into Canadian/provincial corporations and therefore are executing a residence within a corporation. Ontario Municipal Act. Municipality means a geographic area whose inhabitants are incorporated. Municipality. 2. In this act, a reference to a municipality is a reference to its geographical area or to the municipal corporation, as the context requires. Body corporate. 4. 1. The inhabitants of every municipality are incorporated as a body corporate. Black's Law, 5th edition. Incorporate. To create a corporation. To confer a corporate franchise upon determinate persons. See incorporation. Incorporation. The act or process of forming or creating a corporation. What is transpiring through these enactments is contrary to our fundamental rights and freedoms, our natural rights. The executive/legislative bodies are forcing us into recognition as a class of person, incorporating us into the corporation without our consent or knowledge. International Covenant on Civil and Political Rights. Article 8.2. No one shall be held in servitude. Article 16. Everyone has the right to recognition everywhere as a person before the law. We are being forced to play a role and enter into recognition as a class of person, officer, before the law, which is contrary to our natural rights and freedoms. The executive/legislative body have an obligation not to limit or abridge our rights and freedoms. There are natural human rights and freedoms that the government does not create but must respect. Then there are laws which are created through the executive powers of the government that apply against the subject of His Majesty in Canada. Right now, the government is treating you as a subject and servant of His Majesty that who owes allegiance to His Majesty and her laws. What you are seeing is the operations of laws that they have been using against you to yoke your life and create obligations upon your life. Your designation before them is assumed to be that servant and subject, therefore you are obligated to obey His Majesty's laws. Every permit, license that you have ever paid for, whether it be a driving permit, a fishing permit, a hunting permit, no matter what permit, the same operations of law are being used against us. You are being designated a class of person and are being forced to pay for these permits so that His Majesty will confer or give you the right that you are seeking. Financial Administration Act. Charges for rights and privileges. 19.1. The Governor in Council may, on the recommendation of the Treasury Board. A. By regulation prescribe the fees or charges to be paid for a right or privilege conferred by or on behalf of His Majesty in right of Canada, by means of a license, permit, or other authorization by the persons or classes of persons on whom the right or privilege is conferred. Or B. Authorize the appropriate minister to prescribe by order those fees or charges, subject to such terms and conditions as may be specified by the Governor and Council. This is the actual state of affairs right now with your life. You have been placed in a servitude to His Majesty and the government. You have been designated or are recognized as an officer of Canada. His Majesty's ministers are trying to control you life by these legislative rules, these enactments that His Majesty creates or gives force of law. None of what you have learned up to now has anything to do with your natural rights, with your human rights and fundamental freedoms. All these laws are created by the sovereign His Majesty and operate only upon her servants/officers in Canada. This natural human right has found its protection and expression in the international covenants, and Canada, His Majesty, must protect and give effect to this right for whoever claims it. So even though you have been designated under allegiance to His Majesty and are His subject, you do not have to remain in that position and that designation if you invoke your fundamental human right and freedom as expressed above. As you're seeing, you have a fundamental right that is there for you to stand upon and claim. You have a right not to be held in servitude. As you saw earlier, we have been designated as a subject of this sovereign Her Majesty. Her ministers claim that we have pledged an oath to her and, as such, are in servitude. Yet here we have the expression of a natural, right, a human right that states no one can hold us in servitude. The choice is ultimately ours as to what we will claim or stand under. I'm sharing with you a right that is there for you to stand under, but no one can force you to exercise this right. You see, a right never creates an obligation for us, but an option. Legal right. 1. A right created or recognized by law. Right? Something that is due to a person by just claim, legal guarantee, or moral principle. Looking again into our fundamental human rights, we find the following right enumerated and protected on our behalf. International Covenant on Civil and Political Rights. Article 16. Everyone shall have the right to recognition everywhere as a person before the law. When you use the designation or word person, without any further qualification, this word can either denote or mean a human being, or it can mean an artificial person, legal person. This is a foundational understanding when simply using the word person. Black's Law, person. 1. A human being. 2. An entity, such as a corporation, that is recognized by law as having the rights and duties of a human being. Black's Law, artificial person. An entity, such as a corporation, created by law and given certain legal rights and duties of a human being. A being, real or imaginary, who for the purpose of legal reasoning is treated more or less as a human being. Also termed fictitious person, juristic person, legal person, moral person. When looking at the word person, we see the dual meaning that this word can have either a human being or an artificial person. Armed with this knowledge, we re-examine the following article of law, and we find the following. Everyone shall have the right to recognition everywhere as a person before the law. A human being shall have the right to recognition everywhere as an artificial person before the law. You as a man or women have a right to play the role or enter into the role of an artificial person that's subject or servant of Her Majesty if you choose to. Thomson Newspapers Limited v. Canada, Director of Investigation and Research, Restrictive Trade Practices Commission. While individuals as a rule have full legal capacity by the operation of law alone, artificial persons are creatures of the state and enjoy civil rights and powers only upon the approval of statutory authorities. If you play the role of the class of person, then your full legal capacity is limited and you can only exercise rights granted to you through statutory powers, through enactments and regulations. Class of person driver, regulated and controlled through enactments. Highway Traffic Act, Provincial Offenses Act, Police Act. Class of person homeowner, regulated through enactments and bylaws. Class of person student, regulated through enactments, Education Act. Class of person patient, regulated through enactments, receives limited health care. Class of person consumer, regulated through enactments, Consumer Protection Act, ECT. Class of person criminal, related through enactments and criminal code. All these classes of persons are part of the body corporate designated Canada, and you have a right to decide if you will enter into recognition as a class of person and give up your full legal capacity. Supreme Court of Canada. Authority of Parliament in relation to the Upper House. 1981 SCR 54. Date: December 21st, 1979. Further, although S. 91-1 gave the Queen the power, with the advice and consent of the Senate and the House of Commons, to alter the Constitution of Canada, except in certain expressly designated areas, it does not confer a power to amend the BNA Act. The word Canada in S. 91-1 does not refer to Canada as a geographical unit, but refers to the juristic federal unit. In domestic law and the Constitution Act of Canada, 1982, we find the roles of everyone, person, and citizen. Each one of these designations are different in law and have different rights and freedoms available to exercise. Only a man or woman can stand upon and exercise their full legal capacity, their natural rights and freedoms. The Constitution Act, 1982, Article 7, everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof except in accordance with the principles of fundamental justice. Article 10, everyone has the right on arrest or detention. Article 3, every citizen of Canada has the right to vote in an election of members of the House of Commons or of a legislative assembly and to be qualified for membership therein. Article 6.1, every citizen of Canada has the right to enter, remain in, and leave Canada. 2. Every citizen of Canada and every person who has the status of a permanent resident of Canada has the right. Article 11, any person charged with an offense has the right. International Covenant on Civil and Political Rights. Article 9, everyone has the right to liberty and security of person. Article 14, all persons shall be equal before the courts and tribunals. Article 16, everyone shall have the right to recognition everywhere as a person before the law. Article 25, every citizen shall have the right and the opportunity, without any of the distinctions mentioned in Article 2 and without unreasonable restrictions. Article 26, all persons are equal before the law. As you see in international law, we find the same players, the same roles available to operate under. We find a everyone, person, and a citizen. Once again, each of the designations offers different rights and freedoms that can be exercised. The Constitution Act, 1982, Article 7, everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof except in accordance with the principles of fundamental justice. Graham Garton, The Canadian Charter of Rights Decisions Digest, Justice Canada, read as a whole, it appears that S. 7 was intended to confer protection on a singularly human level. A plain, common-sense reading of the phrase, everyone has the right to life, liberty, and security of the person, serves to underline the human element involved. Only human beings can enjoy these rights. Everyone, then, must be read in light of the rest of the section and defined to exclude corporations and other artificial entities incapable of enjoying life, liberty, or security of the person, and include only human beings. Natural right, a right that is conceived as part of natural law and that is therefore thought to exist independently of rights created by government or society, such as the right to life, liberty, and property. See natural law. The enactments and regulations that the government create to rule and restrict you are limiting and abridging your fundamental rights and freedoms. You must contact the government and invoke your charter rights and freedoms in order to break this power that the government is using to try and restrict and control your actions. R. V. Hines, 1999, Kenai 18979, NLCA 83. Prior to the Charter's advent, the individual really had no special means of protecting against incursions upon his or her basic fundamental rights by executive or legislative arm of the state. The Law and the Constitution, University of London Press, 4th edition, points out at page 42, hinges the existence of public order, mandated compliance with directives and ordinances, even if they infringed upon individual fundamental rights and freedoms. 84. A primary purpose of the Charter was to change this relationship of the individual with the state and its laws by endowing individuals with an effective means of challenging acts of the state in courts on the ground of violation of their constitutionally protected rights and freedoms. Slate Communications Incorporated v. Davidson, 1989, 1 SCR 1038, 1989. It follows that any body exercising statutory authority, for example, the governor and council or lieutenant governor and council, ministers, officials, municipalities, school boards, universities, administrative tribunals, and police officers, is also bound by the Charter. Action taken under statutory authority is valid only if it is within the scope of that authority. Since neither Parliament nor a legislature can itself pass a law in breach of the Charter, neither body can authorize action which would be in breach of the Charter. Thus, the limitations on statutory authority which are imposed by the Charter will flow down the chain of statutory authority and apply to regulations, bylaws, orders, decisions, and all other action, whether legislative, administrative, or judicial, which depends for its validity on statutory authority.